Welcome to Q&A practice. Let's start out with this very short Q&A and we'll get our fingers warmed up. Let's start with defense attorney. Ready? Here we go. And that fence post we'll show you in just a moment, but we have seen it many times already. That sort of fence post that's leaning up against the right of the car, that was pulled away. Yes. The branches were uncovered. Yes. Could we have a quick sidebar, Your Honor? Sure. All right, Mr. James, during the break we were able to get this exhibit that we saw yesterday, Exhibit 143, up on the screen for you. Do you see this area in the center of the screen where there seems to be something covered by a tarp? Yes, I do. Did the pilot look like that to you when you first arrived? No. You never saw it in that condition at all? No. Counsel, could you just minimize it back to the desktop and then show us again the electronic signature for that, please? Can you see that counsel has put his cursor over this photo now? I don't know if you can read that. It says date picture taken 11/5/2003 at 4:16 p.m. Yes. All right, now it's your testimony that you got to the scene of this pilot right around 4:16 or 4:15 p.m., right? I arrived on the scene around 4 p.m. 15 minutes to a half hour later, we were taken down to the pilot. Well, if it was 4:15 when you got to the pilot, then the date or the time stamp on this photo is either an error or your memory is an error, right? Because it wasn't like that when you got there. Well, I gave you a window of time. I'm not saying I arrived at 4:15. I do not know that. I estimated roughly 15 minutes to a half an hour talking with the investigators under the canopy. I don't have a record of exactly when we went to the pilot. All right, and you mentioned that it was sort of misting at that point, but it wasn't really raining very hard or at all. Yes. Did it appear that it had been raining before you got there? It seemed to have been. There were puddles. All right, so you tell me for a minute, maybe I misunderstood the sequence here. At some point you talked about it being lightning and very dramatic, I think were your terms, right? When was that? That was near the time we were leaving, so more like 8 or 8:30, something like that. Yes. But at some point before that, was it also raining while you were there? Yes. Do you know when that started? I didn't keep track of the weather. I think you said just after dark it began to pour. I remember it was raining pretty steady while we were looking at the burn barrels. It was dark out. Alrighty, so just a bit of a warm up there. And now let's try some colloquy practice. All right, we will start with the defense attorney. Ready? Here we go. Well, if evidence came in like that, it would be that she stole some things. She was contacted by the police. She agreed to bring them back. She returned the items at a later date. She denies any theft according to what Mr. Franks says. Yes, she does. She says that, oh, somebody said we could just take these things. Well, you can do that. I suppose you can do that up one side and down the other, but you are just not going to get her to be forced to admit she stole something. Okay. Isn't it true that you took something that my client did not tell you you could take, and you're mad at him because he called the police and was she arrested? No, I don't believe she was arrested. Okay, that is basically all I would allow. Thank you. You know it's noon. We are going to have to take our break at this point. We have gone through everything that we had to discuss for Mr. Frank's motion in limine. We also discussed the issue regarding the clothing, which based upon our offer of proof, if the offer of proof is that these clothes were clothes that belonged to Mr. Perez, Mr. Allen, I'm going to rule that the McMahon testimony is admissible. That there was. The reason I suggest that is because this is one of those things where it's highly prejudicial. Just 1 second, I don't want to truncate your argument, therefore I'll treat that as a tentative ruling. Certainly there will be no discussion of that in front of the jury or the jury panel during jury selection, but we will take a recess at this time. I'll see everybody back at 1:30. Hopefully we will have clothing for Mr. Perez at that time. Thank you, sir. You're welcome. Right, another short bit there. Let's see here. Let's try this colloquy. And we will start with the court. Ready? Here we go. All right, ladies and gentlemen, we'll take a 10-minute recess at this time. I'll see you back at 5 minutes after 11. Remember my prior admonition to you not to form or express any opinions on this case, nor to discuss any issue related to it until such time as it is finally submitted to you for your deliberations. 5 after 11. All right, just very briefly, Judge, it's difficult for the people to swallow the fact that defense counsels had this information since March 2nd. This officer was on defense counsel's witness list. This is very pertinent information of a witness, and I guess I don't know what I'm asking for, but I'm not sure what kind of remedies are available for the people. Okay, therein lies the problem. First of all, at sidebar, we did have a sidebar regarding the report, and at that sidebar you indicated to me that you had seen a report yesterday of this particular witness, that wasn't a problem for you, but you just needed to locate that report before you concluded your cross-examination, and indicated that you wanted that witness subject to recall so that we could proceed without you having the report. It appears that during your cross-examination that report was provided to you. Correct. Okay, so the only remedy that this court would have been willing to give you had you objected to the calling of that witness prior to the witness taking the stand would have been to give you a brief delay so that you could prepare to confront the information provided by the report. Your objection, at least from the court's perspective, appears to be now that it was an untimely disclosure. However, it seems rather strange to the court that you would now suggest that you needed time to confront that report when you didn't need time to confront that report before I understand your objection is you feel slighted because it appears by virtue of the witness's testimony while on the stand that the defense has been in receipt of that information as of March of this year, or maybe even sooner. March. All right, am I correct? Yes. All right, Your Honor, it's not the fact that it's do you need additional time to confront the witness? No, but I mean, can I briefly respond, Your Honor? It's just 1054 requires reciprocal discovery. Okay, I understand that, but I also have noted throughout these proceedings that some of the discovery coming from the people has been handed over during the course of this trial. For example, review of particular rap sheets of the people's witnesses. That's correct, but that was discussed beforehand, and there was no misunderstanding. That's a lot different, Your Honor, than a witness saying, oh, by the way, the victim stated she's doing this for money. That's a big difference, Judge. I understand that, except that you knew about that yesterday before the witness took the stand and you did not object. And again, you did not object. Now you're offended because of the lateness of the discovery, that they had it for a lot longer than you had thought. You're right on that, and I honestly think that probably defense counsel, I think in talking to him, just didn't know he had it, and I know him to be an honest person, but I just don't know what kind of remedy is available, and I guess there's none, is what the court's saying. The only remedy that would be available at this point that is meaningful would be sanctions as to defense counsel. That's not what I'm asking for, and very good that you're not asking for that. Don't worry, defense counsel. I will give you an opportunity to be heard on this particular issue. In terms of prejudice to the people's case and the reason I wouldn't give any remedy with respect to destroying or admonishing the jury to disregard the testimony of Officer Landers, I wouldn't ask for that, so we don't even need to address that. Well, I do need to address it because it's been brought up. It's on the record now. The reason that I'm not inclined to do that is because the impeachment effect that you could get by virtue of the late discovery has already been adduced in front of the jury. This court does not favor instructions like Calgic 2.28. The reason for that is there are a myriad of cases suggesting that it is inappropriate to draw to the attention of the jury actions of counsel as opposed to the merits of the case, and for that reason I would not give any type of instruction insinuating that they should draw any negative inferences from that. You have the facts adduced. Having said those things, Mr. Wallace, you wish to address the court on this issue? I apologize for that cough. All right, we will stop there, and that will conclude our Q&A practice.